Hello and welcome to Newscentre. I'm Parikshit Luthra. The Supreme Court has stayed its November 20th judgment, which had accepted the 100-metre definition of the Aravalli Ranges after it triggered a public outcry. The apex court has instead proposed a fresh, high-powered committee to assess the recommendations of all earlier committees on the definition of the Aravallis. Last month, the Supreme Court had accepted a uniform recommendation of the Environment Ministry that defined any landform with an elevation of 100 metres or more above local relief as part of the Aravalli Hills. It had led to massive protests across multiple states, with farmers, activists raising concerns over the ecology of the ranges. The new committee has been given the mandate to conduct a detailed identification of areas that would be excluded from protection, analyse whether regulated mining would result in ecological damage, and clarify whether regulated mining would be allowed in gaps. It must also ensure that ecological continuity is not compromised. The court has called for an exhaustive and scientific determination of the Aravalli range. Further, it observed that the definition of the Aravalli range creates a structural paradox in which protected territory is significantly narrowed. It added that it must be examined whether restrictive demarcation has led to the creation of non-Aravalli areas, thereby allowing indiscriminate mining in areas excluded under the definition. Environment Minister Mr. Bhupendra Yadav welcomed the decision of the court, stating that he is committed to extend all assistance and that a complete ban on mining with the states stands as it is as a result of the Supreme Court's order, and the government will do everything it can to support the process in the Supreme Court. Joining me now to take this forward are Supreme Court of India advocate Varun Kumar Chopra and also former Haryana Principal Secretary MD Sinha. Thank you very much, gentlemen, for joining us. Mr. Sinha, would you say that by putting the definition of the Aravallis in abeyance and asking for a new committee to be constituted to look at all these clarifications that are needed, in a way, the Supreme Court has said that this matter needs a complete fresh look and we are starting from zero?
The court today, in fact, has done the very right thing. In a very interesting move, the judges did not hear any argument. And they, in fact, had done their homework quite well. And they came up with a list of observations and questions that, and highlighting the major concerns that have appeared in the public domain and raised by people like us who have worked for decades in these hills. And by asking these questions, the court has, of course, reiterated very emphatically the principle of judicial oversight over the executive. So, and it has also questioned that these things need to be examined by domain experts, and the previous committee did not have domain experts in it.
That's an important point. Varun, if I were to ask you, what is the most important clarification that is now needed?
Right. So see, primarily the court has observed about 5 clarifications the court have sought for. However, the most important, which I ex facie believe, is the evidence which the court might have to look into with regards to the number of hills which are from 1,048, which has been defined, out of 12,081 hills, whether they are above 100 meters. So that is a very, very critical clarification which the court has sought, in my opinion.
Right. Mr. Sinha, coming back to you, the court has said that there is a need to examine whether the definition had inversely broadened the scope of non-Aravalli areas. Would this definition, the current form, made it easier for unregulated mining to continue? And when it comes to the future course of action that the court takes, how do we strike a balance between ecology, what is best for environment, for people, and what can be done for the interest of industry?
See, again, having worked in these hills, I can tell you that even by no stretch of the imagination will more than 10% of the area come under 100 meters and above. Why did we need to define the Aravallis when we had a very good working definitions already? Every Patwari, the lowest revenue official, knows what constitutes. Every senior officer, deputy commissioner in the 34 districts knows what the Aravalli is. So the entire play for changing the definition has has always been a well-planned move to get out or go around the restrictions imposed by the courts and the early government orders. So this, in my opinion, would have converted a large ecological integrity into hundreds of smaller zones. A very long wildlife corridor, biodiversity-rich regions would have converted into small isolated pockets. That's destroying ecology. Why do you want to save the Aravallis? We don't want to save the Aravallis because they are 100 meters high or 110 meters high, or they are 500 million year old or 3 billion years old. We want to save the Aravallis today for the ecosystem services they offer. That has nothing to do with the age of the hills. I would still urge the court not to fall into this definitional trap.
That's an important point. Coming back to you, Varun, that yes, when it comes to legal protection for the future, because in 2010, the Supreme Court had not accepted the 100-meter definition. The empowered committee, the centrally empowered committee, had previously rejected a proposal by the Rajasthan government, also not agreed with the 100-meter definition there as well. So there have been enough precedents on this within our own system. Yet the Supreme Court, on the recommendation of the Central Government Committee, accepted that 100-meter definition. What kind of legal protection should the court must now provide so that this situation doesn't erupt again in future?
So see, like you are absolutely right. Yes, there were precedents, and that is the only reason the court, the Honorable Supreme Court, has taken this suo motu cognizance of this matter. And if you see the court very beautifully, also it articulates it, that this public dissent and criticism appear to stem from previous perceived ambiguity and lack of clarity in certain terms and directives issued by this court. So that is the sole reason the court has gone into this and sought these clarifications. And court, in its right wisdom, also at the end of the court's order, it goes back and puts in place the FSI's 2010 definition. So you may please appreciate and understand what the intent of the court is today. Going back to that 2010 definition, or going ahead with this 100-meter definition, which created so much of ambiguity and so much of criticism in the public and even the environmentalist, and as my colleague Mr. Sinha said.
Right. Mrs. Sinha, you've done so much of work when it comes to the forests of Haryana. If this 100-meter definition had been accepted as it is, what would have happened in future with regard to mining, exploitation of this Aravalli range? And number two, should some sort of regulated mining be permitted in the 500-meter gap between hills? Can this be allowed, or will there be dangers related to it? Because these are issues that the Supreme Court will look at.
See, if this definition had gone through, many of the... working as a policymaker sitting in Delhi is very different from working in the field. My DFO, when I was conservator here, my DFO stopped many projects which did not, which were tried to be done in areas which would be termed as deemed forests and all. A very prominent gentleman of our country owns 2,000 acres, 30 kilometers from here in Mangar and Kot villages. The entire 2,000 acres of area gets out of the Aravalli regulations. That alone is worth 20,000 crores today. So these kind of things would have been done ad infinitum in many of the villages today. The question is not whether all hell breaks loose tomorrow, but the next 10, 20 years, these things would become very, very dangerous for us to do. As regards the...
Mr. Sinha, one more quick question before, because I'm running out of time. One thing is about regulated mining, but what about illegal mining that is taking place in Haryana? Currently, that is not there in the discourse. How bad is that situation? What is the extent of illegal mining taking place as we speak in 4 states?
See, it's not only in Haryana, it's also in Rajasthan and all. It's all, see, because of the fact that the Supreme Court had banned mining in Alwar and Gurgaon, uh, this opened up the scope of a lot of illegal mining. And there are many areas that where my forest staff or even police wouldn't go in the night without adequate support. So it's been quite rampant. It has always been there, but now it has increased the amount. It has become more and more rampant now. It is whether you can we say stop it? Yes, with proper safeguards we can stop it. But for that you need to have very clear government directions.
Right. And clearly, when the government intends to do something, they always can. Let's see the kind of stand, the kind of clarifications the government now makes in the Supreme Court. Thank you very much, Mr. Sinha, Varun Chopra, for joining us on the program, giving us your views on a very important decision by the Supreme Court to put the 100-meter definition in abeyance. They will now be hearing the matter in January. Time for a short break here on Newscentre. But on the other side, the government's Defence Acquisition Council approves proposals to acquire weapons worth 79,000 crore rupees. A special discussion with Dinakar Perry of Carnegie India and Jyoti Gupta of Nirmal Bang Institutional Equities when we return.